recording.
Okay.
Have you seen any recording signals?
Yes, sir.
Yes.
I have.
Okay. I was
Yes,
hoping we could record so that it will make it easier for you to review the lecture and then do whatever revisions you have to do. Now,
Thank you.
Most of what we try to do when we talk about the domain of jurisprudence is to use the domain of jurisprudence as an introductory lecture for you. So a lot of interaction will be ongoing while the lecture is in progress. Our understanding of jurisprudence, what are the boundaries that have been placed in terms of jurisprudence? What kind of view should we have of jurisprudence? Should it be a local view? Should it be a world view? Is there anything such as a universal view of jurisprudence? Now, in this process, we are also going to expand our minds in terms of how we think, which is why I said there is a lot of inclusion. When we talk about Western jurisprudence, we don't just talk about jurisprudence from the perspective of the Wells, the Salmons, the Durkheim, the Henry Mains, and the John Austins and all that. We have to understand from the get-go that there are other types of jurisprudence that abound. There is Jewish jurisprudence. There is a Christian canonical jurisprudence. There is also a kind of jurisprudence right now that is pervading the world that people are not even taking notice of, some kind of secularist jurisprudence. And it's probably, in fact, the most impactful and the most powerful jurisprudence that is currently in the world, even more powerful than faith-based jurisprudence. And somehow that is flying under the radar, because when you look at constitutions and we are beginning to have ideologies in terms of separation of religion from the state. That is some kind of secularist jurisprudence that is ongoing. If we talk about the way science is beginning to take over the world, it comes from that secularist foundation. Things like the battle for the right to things like the right to abortion, right to use stem cell technology, which basically is made up from the stem cells of aborted fetuses of unborn children and all that. So when we look at some of these things, we need to relate it to jurisprudence, to functionalize it and understand that these are ideological issues that the world is facing, well beyond just legal issues. And jurisprudence provides the portal, the channel for you to have those kinds of discussions. Any comments so far?
No, sir.
Well, with you, sir.
Okay. Now, please, you can interject any bloody time you want, because that's the purpose of why we are here. And I always tell people that at all times, please try to object. You start by doubting.
All right, sir.
You start by doubting. Whatever I tell you is a perspective. That is my perspective of, it's not, there's nothing, you can see law of evidence and it's written in stone. This is the law, this is how it is, but it's not the same way with jurisprudence, because whatever it is just one person's perspective. So your mind has to be open and understand that this is, it's not an adversarial situation. It's more of a cooperative situation where ideas come together and we are testing those ideas. So the next question, of course, is what must be the approach to study law? A lot of people will say jurisprudence. Who can any of you give us some kind of working definition of what jurisprudence and legal theory is?
Yeah.
Nobody?
Simply put, sir, I think jurisprudence is just is a study or is a study of the theory of law, just as you have pointed out earlier, sir.
Thank you. The study of the theory of law.
Yes,
Now, jurisprudence, again, offers the only outlet for law scholars to study law outside of the law, which means that we are using instruments, tools that are not normally used as the instance of legal scholars. So when we are discussing jurisprudence, we are discussing jurisprudence more from a socio-legal perspective than a strictly legal perspective, which is why you find out that the language of jurisprudence sometimes is almost a sociological language as against the yes and no legal language that we normally use. So when we approach the study of law, we approach the study of law from, by my estimation, 3 basic premises. Number 1, we look at it from what is the nature of law. And it may not be law itself. It could be something within law. It could be rights, for example. What is the nature of rights? What is the nature of a felony? What is the nature of trespass? It could be other things. It could be institutions within our legal system. What is the nature of a prison system? I hope we are still together.
Yes, sir.
Now, when we say the first thing is the nature of something, the next thing that we focus on, number 1, if we have understood the nature, and I use this for my class all the time, we talk about marriage, for example, and then someone says, I want to get married. And someone else says, yes, but let us look at what is the nature of marriage. It means 2 people coming together to the exclusion of other people, right?
Yeah.
Marriage talks about things such as conjugal rights as between the 2 couples that are coming together, right?
Yes.
Yes, sir.
It talks about loyalty, and it talks about submission of both to the common cause, right?
Yes, sir.
Now, all those things that when you talk about nature, all those things are the things that you call nature. You are looking at what it is. What characteristics does it have? Why are we calling it this particular thing? And when we use a marriage as a simpler example, we can go into other things, other concepts in law, such as possession, ownership. If you say somebody possesses something, what does possession entail? What is the nature of possession? If you say he does not possess it, it's just a, or for example, if it's a will, somebody dies and you're talking about illegacies, rights and things like that, then again, other than the general, trying to find out the general nature of rights, you are trying to find out the specific nature of a legatee's rights. I hope we are still together.
Yes, sir.
Then the next thing is, now having known this nature, how do I apply? What is the application? If you say you are studying law by nature, application, and purpose, how is law applied? Obviously, law is applied by, it is made by the legislature, applied by what we call the judicial system, right? Mr. Emmanuel, I'm not hearing you much. I hope you are still, I'm not hearing you. Give me assurance that you are hearing us. I hope you are still with us.
I'm with you, sir.
Okay. Now,
yes, sir.
For application, we now ask ourselves, what are the things how is this concept or this element, how is it applied? How do you apply law? What are the institutions that have been set in place for this application? You have the court system, you have the police system, you have the prison system, you have lawyers in their chambers. All that, if we study all that, it is still part of the application, how law is applied, that we are studying. Then if we talk about, I keep projecting that over marriage to make it simpler. If we also talk about marriage, for example, and we are talking about application, how is marriage applied? Marriage is applied in the things that we do with marriage, such as the living together, the conjugal rights of both parties, having children, right? And doing all the things that marriage entails. Then again, at the end of the thing, when we have looked at the application of whether it's a concept or whatever, at the end of it all, we look at the purpose. What is the purpose of this thing? Why does it exist? If we look at law, for example, why do you think law exists?
To create order in the society.
Fantastic. As a social control measure, right?
To create a balance that...
To create what?
To create a balance that...
Okay. Now, if it's to create that, but there are also more noble purposes for law. One is the delivery of justice, right? Hello? Hello? Okay, we had some network issues.
We are back on track.
Hello. What network do you use, Emmanuel?
I use MTN.
Okay, I use Airtel. Apparently, my wife was complaining too that at the university yesterday, they were having issues, everybody was having issues with network.
Okay, sir. That's well.
We are still waiting for her to be around.
Yes, she said she's trying to log into.
Okay. So what year did you graduate from Unijust?
I graduated 2012, sir.
2012. So you've been practicing for a while now.
Yes, sir.
Or you're not practicing, you work in a corporate institution.
Yes, sir. I was actually not practicing. I started practicing 2 years ago.
Okay, where were you working before?
I was working in a firm in Lagos.
Okay. So I think Oyinlo is around now, right?
Yes, she's around.
Okay, so let me try and share the screen back and so that we can continue.
All right, sir. Very good.
Okay, so and we said so what we try to do is find out what the purpose is. We were talking about what the purpose of law was. I think, Abimbola, you were saying something.
Yes, sir. Can you hear me, sir?
I can hear you clearly.
Okay. You were asking what the purpose of law is, and I was saying that to maintain order and to create a standard where the good is defined from the bad.
Okay. Maintain order, a standard where the good is defined from the bad.
Yes, sir.
Emmanuel, what do you think?
And the attachment of possible consequences where a member of the society tilts towards the bad.
Fantastic. Any comments, Emmanuel?
Yes, sir. Since law is backed up by an apparatus of sanction, law is just to maintain, a situation where there is no law in the society, anarchy will be the result. So in order for such not to be in the society, law is set to prevent the reign of anarchy in the society, just as she pointed out too, sir.
Okay. Fantastic. We are doing very well. Now, it now becomes, of course, we are trying to define what law is, and we can't really have a specific definition. Professor, what was this professor's name again? That's a Nigerian professor that said nobody can define
law.
The law.
Professor
Okunuga. Yes, thank you. Professor Okunuga, who basically said nobody can define the law. It's like a wasted exercise. But we keep trying to define it. And usually what we have is what I call a working definition. It means you define it in a way that works for you in particular circumstances, since it's almost impossible to have a kind of universal definition of what the law is. Because if you have a universal definition of what the law is, then we go right back to what is the nature, what are the attributes of what you call law. Could it be the kind of social control that went on in Nazi Germany before the Second World War? Because we have said now that it's like a social control and whatever to maintain balance and stability in society, right? Which is part of the attributes of law. But in Nazi Germany, they maintained balance and stability in society by killing Jews and killing some other minority races. Groups. Is that law?
No. That should not be law.
That should not be law. I like the way you put it. That should not be law. Now, is the purpose when we now look at we talked about the nature. When we look at the purpose now, should social control be an end in itself?
It should not be, sir.
What should be the end in itself? what do you think should be the end? What is the eternal purpose of law?
Well, I feel like the purpose of law, just like I said, should be to ensure that a balance is created between that, well, everybody might not be satisfied with whatsoever the law can provide, but I feel like a balance should be created where people accept the people can be able to live in the society without, well, a lot of complaints, because I feel like we all can't live without complaints. But I feel like people should be able to live in that society comfortably. I don't know if you're getting my point, sir.
I'm understanding. You know, a particular statement as you are talking now is being reflected in a particular statement in my mind that talks about the happiness of the greatest number, right?
Yes, sir.
Yes, sir.
The happiness of the greatest number.
Yes, sir.
And there's a presumption that if you get the nature of law right and you get the application right, you will get the happiness of the greatest number.
Yes.
Of course, there are some people that are deviants in society. If the whole society is happy, he will be unhappy that the whole society is happy.
Yes, sir.
Right?
Exactly, sir. Yeah, very well, sir.
Now, the law doesn't take those people into contention when it tries to find out what its nature is, what its application is, and what it is purpose. As a matter of fact, the whole purpose of law may be, in fact, to make sure that it mitigates the effect of those certain elements in society. So if the purpose of law is to mitigate your impact in society, obviously you are going to be unhappy with law, but we digress. Let's move on. Now, we said that there are certain familiarities that run through jurisprudence and legal theory. There are certain assumptions we make, which is part of what I was discussing with you during my introductory lecture, that you make certain assumptions. And we are here to teach each other and to have a conversation as to how to enlarge our minds so that we do not make assumptions. Number one of the assumptions we make in the study of law is that there is a universality of words and concepts. A universality of words and concepts. Let me give you an example. Do you think bribery should mean, do you think corruption, of which bribery is a subset, should mean the same thing globally?
Are we defining corruption now?
Yeah.
Do we think corruption should mean the same thing universally?
Globally.
Well, I think so, sir, in my little perspective. Maybe because of the bias that my environment has given me. If you understand, I've always known corruption to be bad.
No, corruption
I've always known corruption.
The part of the problem that we look at when we're looking at, when we talk about certain assumptions, for example, is corruption. Some of the things we call corruption in Nigeria may not even be corruption in the US.
In other countries.
Would you call a man and a woman marrying each other corruption? A man and a man marrying each other corruption?
No.
If two men marry each other, it's not corruption.
I wouldn't use the word corruption for that.
What word would you use? Hello?
The word corruption captures that.
Homosexuality, right?
Yes, sir.
But is homosexuality a corruption?
It's a perverse way of living. I just don't think corruption is the word that I would use in such circumstance.
Okay, let's find out what is the... Can somebody find the meaning of the word corruption?
Okay. It says a dishonest or fraudulent conduct by those in power, typically involving bribery,
Okay.
or the process by which a word or expression is changed from its original state to one regarded as erroneous or debased.
You don't think homosexuality is erroneous and debased?
I'm thinking. Maybe. I kind of get the perspective now.
Anything that's not anything that goes, that's the problem with the word corruption, because
Yes, sir.
the dictionary language is telling that anything that is not going the way it should go for good is corruption.
Okay. Okay.
That's the general meaning of corruption. Obviously, when you are now looking at the EFCC Act and you are looking at ICPC and other statutes around the world, there is a limitation placed on the word corruption to define it specifically, so that specific rules and regulations can be generated.
Okay,
Yes,
so
sir.
please, if I may.
Please go on.
Now, we says alteration. So perhaps homosexuality can be defined as corruption because it alters the already known way of existence.
Fantastic. That's my opinion. I could be wrong.
Yes, sir.
Not just that it alters the known way of existence, but because it could be seen as being unnatural.
Yes, sir.
And the word unnatural may not be a right word to use, but basically what we're saying is in most of Africa, apart from maybe South Africa and one or two Southern African countries, Africa looks at homosexuality, for example, as corruption. In the West, in Europe, in the US, and some other countries, they don't think it's corruption. As a matter of fact, you're trying to stop it and trying to limit it and criminalizing it is corruption. So we look at these words and these concepts and we say, as jurisprudential scholars, we should not be making assumptions about words and concepts because they may mean very different things. The World Health Organization, for example, talks about prisoners should be given potable water to drink, right?
Yes.
Hygienic potable water to drink.
Yes, sir.
Now, if you are in the UK or the US, for example, hygienic potable water that you can drink straight from the tap will not be a problem, right?
Yes, sir.
So it's part of a concept that is acceptable as meeting the World Health Organization standards for the fair treatment of prisoners. Now, you are not a prisoner, right? Either of you prisoners, God forbid.
No,
Yes,
sir.
Now, can you drink water straight from the tap in Nigeria?
Not at all.
Is water even coming straight from the tap where you live?
No.
Yes,
no
sometimes.
Now, if you are a prisoner in Nigeria, what the World Health Organization is saying is that you are entitled to something that the general population is not getting. I hope we understand.
Yes, sir.
Very well, sir.
So those assumptions, those words, those concepts we say can probably only be looked at within context. So it's almost impossible to look at things from a generalized, universal worldview, because there is no such thing as a general or a universal worldview. And then when we talk as scholars, we must also be aware of our limitations. One of our limitations is our ideology. If you were trained as a Christian from day one, your thinking will always be limited by that faith. If you were trained as a Muslim from day one, your thinking will somehow be thinking, your decision making will be subservient to your faith. Because we try to look at things as if things are, there's a moral pejoration, there's a moral neutrality that we have as people.
Yes, sir.
I'm not sure that is true. Because again, if you say you are secular in your thinking, it must be because you must be secular in your thinking because you are not strong in your faith.
Yeah.
Yes, sir.
I hope we understand. So when
Yes,
we look at these countries where people talk about the separation of church and state, for example, you have to ask yourself exactly what is the ideology that is happening here, and then think deeper about decisions that are making. You look at Nigeria, for example, you have a Muslim-Christian war that is ongoing, which is laughable because you look at the bigger world, across the whole world, the war that is really going on is a war between secularists and people of faith, of which Muslims, Christians, Jews, all of them are lumped together as people of faith. As one, and they are all running for cover because they are in reverse. I hope you understand. Now,
yes, sir.
And we say we can't make those kinds of assumptions. Another assumption is about, okay, we've talked about that. When we talk, for example, about hygienic potable water, for example, what it means in a globalized world. When we talk about morality in a globalized world, what does it mean? If I'm against,
very different from what Nigeria sees it as too.
Very different. If you are in South Africa and you talk about the way we just talked about homosexual practices, for example, if you were in South Africa, you would be regarded as being immoral. And we have not even left Africa yet.
Yes, sir.
30 years ago in the United States, if you talked about homosexuality, you will be regarded, if you say you are a homosexual, for example, you will be regarded as immoral.
Yes, sir.
Just 30 years ago. But today is the exact opposite. So we look at many of these concepts and we say in a globalized world, you cannot make any assumptions. The next one is that jurisprudence, another assumption basically is that jurisprudence is an abstract construct for law. One of the reasons you don't find too many students coming to do jurisprudence in postgraduate studies, for example, is because people say that they are afraid of its abstract nature. Because you are talking about ideas. Some of those ideas are not things that they are not like, I spoke with Professor Oba once and he just looked at that, he said jurisprudence, it's as if me, I don't like that course, so I need lampposts to hold, you know? Because if there are no lampposts and you are talking about things that are abstract in nature, then it can become very difficult. But some of the things we talk about, when people talk about things that are abstract, when, for example, someone talked about the law of gravity. The law of gravity was something that was abstract because the law of gravity was being discussed at a time when people did not even know that the world was round and people were still talking about the world may be flat. So if someone comes in and says there's something called the law of gravity, the way you look at it will be different because there's a concept there that makes the law of gravity possible if the world was round and floating in the universe. But if it was flat, then it will be a completely different kettle of fish. So there's something you call, people like Einstein, for example, 90% of the theories Einstein formulated were theories that were abstract. Because people did not even have the common sense or the technology to bring those theories into life. But it's the same theories that helped in us having a satellite television, cable TV, satellite phones, even the microwave they're using in your kitchen. So jurisprudence is abstract, but that abstractness has to be channeled towards legal events. And when we channel certain things towards legal events, I'll give you an example. One day I sat down and I was analyzing, I think the case was PDP versus INEC, where I think Atiku Abubakar wanted to go and become vice president to Obasanjo at the time. And he had just basically won an election. And he wanted to, and the Electoral Act basically said the only way there will not be a re-election is if the governor-elect dies.
Okay.
You understand? If the governor-elect dies, then there will not be a re-election. The deputy governor will take over. But any other circumstance of the governor leaving office, there will be a re-election. And the case went as high as to the Supreme Court. And what did the Supreme Court say? The Supreme Court brought out Collins' dictionary and was interpreting the word to die, what it meant.
Yes,
and as we all know, when you look at a dictionary, dictionaries come with synonyms that may be different in terms of meaning. Each and every one of those synonyms will be slightly different from the next one.
Yes, sir.
They don't capture exactly the same thing. And the Collins Dictionary obviously did the right thing by saying to die means to, it could be to die biologically, obviously, but it could also mean to wither away, to fade away, to disappear, to, and the Supreme Court chose those options. So we ask ourselves, if this is not a fertile ground for attaching legal event, for attaching jurisprudence to legal events, what is? And part of the problem we have always had is, and I think again, that is why jurisprudence is not as subscribed as other courses. One of the things you look at when you look at jurisprudence is trying to set a foundation, a kind of philosophical foundation for our conduct, both in terms of how we make laws, in terms of how we interpret laws, and in terms of the application of laws. Now, when we look at that foundation, and that is the foundation I think other jurisdictions, other legal systems have, and we don't have. If you have a jurisprudential foundation, then all the laws you make, like Hans Kelsen said, all the laws you make will be attached to each other in consistency.
Yes, sir.
Okay.
So now the next one is to look at jurisprudence as an activity. Okay?
Yes, sir.
If you look at jurisprudence as an activity, it means that you are constantly thinking in terms of how you analyze things and how jurisprudence can assist you in terms of how you analyze someone. And we say these activities can be divided into analytical, which is obviously the way you analyze. It can be normative. It means you can have norms of conduct, the way people behave and all that stuff. And then it can also be empirical inquiries, the way you study things factually. And the next one is that jurisprudence must itself not, jurisprudence must in itself include not just known and familiar structure. Okay? not just
Yes,
known
sir.
and familiar structure, but anything that concerns law. So as we're here and we are talking about things, you know, when we say we're talking about application of law and application of this and application of that, one of the things that concerns law, for example, is to try to get the people that committed crime so that there can be delivery of justice.
Yes.
Now,
Yes, sir.
if you want to deliver justice, how do you deliver justice? By getting the man that committed the crime and not the innocent man that is walking on the streets,
Yes, sir.
right?
Yes, sir.
Yes, sir.
So in delivering justice, if someone now says there's a technology that has brainwave, that can use brainwave, obviously there are technologies that can basically say whether somebody is telling the truth or not. There's the polygraph test, and then there's the brain imagery and all that. Why is law not interested in that? There are certain things. For example, if people that are violent criminals could just have, it may not be a behavioral or a conduct or a choice thing. It could actually, a lot of people who were serial killers were actually found to have been growing tumors in their, what they call the frontal cortex of the brain. That is the part of the brain that processes information.
Okay.
And there was actually someone who was caught, he was a pedophile looking for children to sleep, and they scanned his brain, found out that there was a tumor there. The tumor was removed from the brain, and then that need to be looking for children to sleep with disappeared. But as we know with tumors, the tumor started growing again, and that need started coming back. So some of the ways people behave can be just biological and medical. For a long time, we had all these, you can have an auntie that doesn't talk to anybody, who is always frowning and all that. And we didn't have a word for it, but mental health professionals now will tell you, okay, this, she can be happy 1 second, extremely happy, then the next time, extremely sad. And we didn't understand what it meant. And people are now saying that is manic depression, which is a medical condition that a drug can take care of. And people who are behaving, we have people who are bipolar, they will say he's bipolar, he's this, he's that. And people were committing crimes and then being sent to jail under the assumption that they were acting of their own free will. I hope we understand. So when we study jurisprudence, what we are saying is, because jurisprudence is the foundation for the learning of law, our minds must be open and not restricted by assumptions.
Yes, sir.
A particular serial killer, they call him Wayne Getty, even as he was dying, was saying, I'm going to leave my brain for science. There's something wrong with me. And when he died, I think University of Oxford or something conducted an autopsy on his brain. It was found out that he had a lesion, which is like a scarring of that same frontal cortex.
So if, I'm sorry to interject, but if the more developed society has a problem or took its time to find solutions like this, when do you think a country like Nigeria in Africa will get there?
Probably, they have not even found a solution. That's the thing. All these people I'm naming, is not as if anybody freed them and said that because you had a tumor in your brain, we are freeing you.
Okay.
You understand? That's the point I'm making, that the law is so behind science that it is shocking. People, they are seeing it, they understand that there's a problem. But which is why you also, now when you go into, for example, what we call the theories of punishment, what are you really trying to do? Are you trying to rehabilitate, re-educate? Is it an eye for an eye? I don't really care whether you have a tumor. I am going to kill you because you kill someone. And I think that is where the world is still at currently. So it's not, the Western people have the science to understand that there's a problem, which we don't have that level of technological advancement. But the mentality is still the same, which is even if you have that tumor, you should have had free will, which is an inconsistency in a way. So as jurisprudence scholars, all this thinking are the thinking we need to do for our societies. That is why when I have my undergraduate jurisprudence class and then my postgraduate jurisprudence class, I talk almost like a preacher. It's like I'm on a mission to make us think differently about things.
Okay.
Now, when you think about it, there's also something called a first principle thinking. The first principle thinking that makes thinking easier for most people is, which is what we are doing now, to take something and strip it down to its basic essentials. What is the truth? The absolute truth here. Number one, if you are a poor person and you want to get rich and you're asking yourself, what is first principles thinking? What you ask yourself is, what is the nature of a poor person?
Okay.
Lack of opportunities, right?
Okay.
Could be one. It could be a lack of intelligence. And I don't mean IQ, because a lot of people with very high IQ are in fact very poor people. But it has been found out that intelligence quotient is actually a much, what do I say? It has a much lesser impact on your intelligence in future than your emotional quotient. Emotional quotient is about how you deal with your fellow human being. When you shake somebody, do you smile? When you are talking, do you hug him and say, hello, how are you? I really love the way you are dressed today.
Okay.
That is learning to live as a social human being. It is those, or when you shake someone and you talk to someone, does he feel like he can trust you? If he feels that he can trust you, you are more likely to succeed than the man getting 2-1 and first class in class. So all those things are we'll go through some, we'll try and go through as much as we can go through. Now,
okay.
A conception of the study of law that includes non-state law should not be viewed as downgrading the importance of state law. Is absolutely important, but there are assumptions sometimes that almost as if you talk about something that's non-state law, is somehow trying to relegate state law to something else. Now, we've got customary law. We have all kinds of law. There are conventions.
Okay.
There are also what you call subculture laws.
Okay.
Some of the scholars of jurisprudence will look at what they call subculture laws and say, okay, there are a bunch of people that behave differently. If you go to Lagos, for example, in the old days, I don't know whether they still have people living under the bridge. There were all these people in Morocco and all kinds of places who were miscreants living under the bridge.
Okay.
And they had their own rules and regulation, their own rules of conduct to govern each other. So if you had someone, for example, who went, somebody who is an apprentice with a vulcanizer, for example, commits a crime, they have their own specific way of dealing with each other.
Yes, sir.
And we say these rules are just as important as mainstream law. It means we also have to study those kinds of subcultures. But that does not mean that state law or law advocated by the state is not important. Then we also have to understand that secular incarnations of law are not the only incarnations of law. When someone comes and he says, I'm morally neutral, which means I do not bend towards any particular faith-based ideology. So because of that, I'm somehow more pure in my thinking. And if I'm purer in my thinking, then my thinking has to be superior than someone whose thinking is subjected to faith, to some kind of faith. You understand? Because we talk all the time about moral neutrality, and someone says I'm morally morally neutral. Most people who talk to you are just talking from his own perspective. So jurisprudence has to continue to advocate for us that people must talk from you have to, when someone talks, just the fact that he wrote a book that is 1,000 pages does not mean that he's not talking from his own perspective, and that there's something is morally neutral in what he's saying. We are all talking from our perspective.
Yes, sir.
The question is whether our perspective can solve the problem at hand.
Which most times does not.
Which most times it does not, because we are naive in Africa. We sit down, we think we do not have any solutions for the rest of the world in Africa, and we sit down like babies just waiting to be fed. Now, I was in a country where someone came out trying to use African cultural practices relating to marriage as a way to stop women in America from divorcing, to stop Black American women in America from divorcing each other. I sit down here and I can also tell you that the Igbo practice of the apprenticeship system is probably one of the most efficient ways of moving people from poverty to
wealth.
Yes,
sir.
More efficient than any investment. Because what the Igbo man does is he teaches his boy how to sell. He teaches him how to, over a period of time, the boy serves an apprenticeship program, grows old, and he grows to be an adult. Why with this person? Then when he finishes his apprenticeship his oga will now settle him by not just giving him money and assisting him to open his shop, but by giving him some of his customers, some of his own network.
Yes, sir. That's true.
So, and it is probably the most efficient way to create capacity for people where they learn and also to create wealth. So we can't sit down as Africans and look at ourselves like we have nothing to offer the world. And for the marriage thing, one of the greatest problems in the US, for example, is 70-something% of the people that are in the penal system come from broken homes. And when you know how children are, they think they are being smart. When their father and their mother don't live together and they are separated, they know how to play the system. They will say, go to the mommy and say, daddy said this. That one will give him chocolates and give him money. Go to daddy and say, mommy said this. And that basically turns them into people with behavioral problems.
Yes, sir.
And an African is saying, if you are going to marry, both of you shouldn't just go to the registry and go and sign paper and get married. Take your family. This other one will take their family. They have a dinner. They do what they call introduction. After introduction, you now go ahead and do so. You go with your uncles and go with the family members. After that, you now do so. And so why? Because before you can divorce each other, each of you must go back to the people they brought for that introduction to explain why.
Yes.
When people want to divorce each other, the false shame of it is having to go and explain why to people that you respect. You know, so, and what we're saying is secular incarnations are not the only incarnations of law. When people say, I have an incarnation of law that is canonical in history, or I have an incarnation of law that is Jewish, or I have one that is Hindu, or I have one that is Sikh, or some kind of pygmy ideology. They are not things people should be ashamed of in the face of secular incarnations of law. Because secular incarnation of law may very well be a faith system in itself.
Yes.
Then the other one is that, particularly for African scholars of jurisprudence, there must be new impetus must be given to alternative philosophies. What is our thinking? What do we believe in? If we do not believe in so and so, why are we advocating or following organizations and people that believe in those things? For thousands of years, for hundreds of years of academic thought, Africa did not even have what you call, we couldn't even say we had something called an African jurisprudence. Why do you think our legal system and all those police does not want to arrest people except to extort money? If he knows he's just going to arrest you and then you end up straight in court, there's a certain reluctance. Judges show a marked reluctance to convict people for prison terms and all that. You can see that. In the streets, when people happen, the African, the Nigerian is more likely to say, hey, just forget it. He has learned his lesson. So we have a philosophy of reconciliation rather than a punitive philosophy.
Yes.
Why don't we recognize that and then now ask ourselves, is this what we want or not? Does this help us in our aspirations? And what are our aspirations? Our aspirations, the second one says it is developmental. We have developmental aspirations we want to develop. So what are the things that will assist us in developing? So let's go to the next one. So because of all these, when African scholars sit down to talk about jurisprudence, we must look at jurisprudence from 5 different perspectives. I hope Mr. Emmanuel is still around.
I think he's muted. I'm not sure.
Yes, I'm with you, sir.
Okay.
Yes, sir.
Now, we must look at it, number one, as ideology. You look at jurisprudence as ideology.
Okay.
And part of the problem, I think most of us in Africa is we are not even aware that we have an ideology. And you have to be aware that you have an ideology, strip it down to addressing that ideology, analyze it, and understand whether that is the ideology that you want to have. And I think jurisprudence can help people in terms of developing a specific ideology. I give this example to people. There are the technology exists where your clothes on your body can be removed layer by layer, which means if you pass through a body imaging machine, for example, in an airport, they can remove your clothes, remove your pants, remove everything from that. But there's an ideology of the right to privacy, right?
Yes, sir.
So even though the technology exists, it cannot be used in airports, even though that will be the most efficient machine to use to stop people from carrying bombs into the airport.
Yes, sir.
Or drugs.
And for that, they use what? They use metal detectors and X-ray machines. Even though the technology exists to use something much more efficient. Why? Because of the right to privacy, which they have prioritized as being more important than the right to security.
That's the ideology.
That emanates from ideology.
Yes,
so
sir.
you will now find that every law that is being made will be made in an organized, systematic manner. Because of the underlying ideology relating to certain phases of their lives. And it is this ideology that we must spread around and make ourselves understand it. 2, law is the study of law, philosophies and theories must be seen as a heritage. It's like the old babalawos in the old days, where somebody, the herbalist, he puts herbs together, it cures malaria.
Yes, sir.
Why? When he dies without knowledge.
Not transferred to anybody.
So there isn't a continuation of the reason why people in the West are not smarter than anybody. The reason they are technologically advanced is because of that passage of information. So the next generation don't have to start from step 1. If the last generation did it to step 15, the next generation starts from step 16. Ordinarily when you ordinarily look at what's happening in Nigeria in terms of governance and all that, every 4 years, if a new governor comes in, you are starting from step 1. So it's not treated as a heritage, as something that can be. And then again, we say Jurisprudence as a science of law must show its usefulness by solving legal problems.
Okay.
It must solve legal problems. Obviously, one of the subsets of jurisprudence is interpretation of statutes.
Yes, sir.
As lawyers, what are we?
Yes, sir.
What's the one word you think we are as lawyers?
Ministers in the Temple of Justice.
Ministers in the Temple of Justice. Yeah, fantastic. Ministers in the Temple of Justice, which is in one word. But as a minister in the Temple of Justice, what you do is what? Interpret. You're an interpreter. Because you are not carrying guns to shoot anybody. What you are doing is looking at the law and saying, this is what the law says, period. Of course, you can have ways of application. You apply for a rule, you file your brief, you file your record of this and do. All that comes right back to interpretation. You're interpreting the law. This is what you think the law means. Which is the basis for when you do jurisprudence. Interpretation is a cornerstone of interpretation of law, is a cornerstone of what jurisprudence does. And we must use this interpretation in terms of solving legal problems. When you look at some other jurisdictions, for example, the way they interpret is directly related to what they think their societies need. The way law was being interpreted was different during the period where the United States, for example, was focused on the war against terrorism.
Yes, sir.
Where it was said that offshore prison camps like Guantanamo Bay were legal. Where there was something they call rendition, which meant, for example, that if you put a terrorist in a plane and fly him above in space, you could actually do things that will not be susceptible to laws within the US while there. So you found agencies, some intelligence and security agencies having rendition programs and things like that. Now, because of the onslaught of the internet, a lot of people have forgotten all these things. Which is why I say sometimes never in world history have we had so much information, and yet never in world history have we been so uninformed. So, again, one of the things we do is we also look at the domains of areas of inquiry, which is a focus. And when we are doing that focus, we are looking at it from the perspective of what? Things like infrastructure, subject matter, legal precepts, and all that. And there are basic things that you learn as a jurisprudence scholar. One of it is you look at what you call the sociological matter. When you look at the sociological matter, we say, reading from here, that it helps us to study law in a functional manner as an instrument of social change. You know, my little discussion with you, Abimbola, I can call you Bola, right?
Yes, sir.
Abimbo, sir.
Abimbo, okay. Now, you talked about one of the things that interested you in jurisprudence was social justice as a concept.
Yes, sir. Yes, sir.
And what the sociological matter is talking about here is that you must look at law functionally as an instrument of social change.
Yes, sir.
So for us in Africa, for example, where our problem is developmental, we are not developed. It means every law we have must be interpreted in a manner that talks about developing and getting better.
Yes, sir.
Then we also talk about, and we call that the sociological matter. But there are also other things. There is the historical matter, where you look at law historically. What was it before? What is it
Yes,
now?
sir.
What is it likely to be? Right?
Yes,
There are
sir.
also philosophical matters relating to law. When someone is talking about certain concepts of law and all that, what is the philosophy behind it? Why do we have a law, for example, against trespass? In California, why do we have what they call the Make My Day law? There was a movie where there was this vigilante who just went around shooting people, acted by someone called Clint Eastwood, one of those police movies. And he goes around shooting people. And then when those criminals, there was a lot of crime in his neighborhood. When they come in, if he's about to shoot you, he will say, make my day. Just move. All you need to do is move and you make my day because I now have the right to shoot you.
Wow.
And California had what they call the Make My Day law, which meant that if you see someone in your house or in an environment that is legally controlled by you, and you have apprehension for your safety, if you have apprehension for your safety, you can use maximum force to repel that person.
Yes.
So it now doesn't matter whether the person is a thief or he's not a thief. The key thing is, are you afraid for your life when you saw him? So for you guys who just enter in front of somebody's gate and start knocking, try to make a phone call before going to someone's house. So those are that is the philosophy. And that philosophy came about because there were too many poor people in that area, and there were house robbings and very much similar to what you call banditry in Nigeria now, kidnapping and all that.
Oh my God.
So rules like the right to carry arms, the right to bear arms and all those things emanate from specific philosophies. And it is also some of the things we learn in jurisprudence, some of the duties that we have as jurisprudence scholars, that we must evolve philosophies. And then fifthly, that we should be able to have a dichotomy, which in our heads, we must be able to think of what theories, what kind of thinking is universal and what kind of thinking is local.
Okay.
Is this thinking universal? Is this one local? Of course, gender rights as a principle is a universal thing because across generations and across jurisdictions, there has been a patriarchal system in place.
Yes, sir.
Where the rights of women are treated as
secondary.
Without law understanding that there are some specific things that women are exposed to. In my house, for example, I tell the story. The very first day, armed robbers entered my house one day, and you'll be surprised that one of the key things in my head that operated in my head was, thank God I didn't have a daughter. Because I thought the armed robbers could handle, the men could, I have 3 boys, no daughter. And I thought my boys could handle whatever an armed robber throws at them. Now, if I had a daughter in the house, she would be much more afraid in that circumstance than my sons. Why? Because she will be exposed and vulnerable to other things that my sons will not be exposed to.
Yes, yes, sir. Yes, sir.
And we went on for centuries as if these issues didn't, as if these issues did not exist. So you can look at the basic rights to women, for example, from a universal perspective. Then you can also look at it from a local perspective. And when we mean local perspective, we are not just talking about jurisdiction. We are also looking at it from the perspective of faith-based areas. I cracked the joke once, and we normally talk about how does law come into how does law affect us? How is jurisprudence functional? What kind of explanations do you have, for example, for people? When my father died, our inheritance, 4 boys, 1 girl.
Okay.
The 4 boys took whatever it was that was given by Sharia law. And my sister took half of what the boys took.
Okay.
Which, if you look at it from a universal jurisprudential level, was unfair and an infringement of her right to equal gender. It means that the genders were not equal, right?
Yes, sir.
But now this is the kicker. And these are the issues that we ignore as jurisprudential scholars. When you bring it down to local jurisprudence, for example, my sister, from the money I got, I paid the school fees of some of my younger brothers.
Okay.
My sister wasn't called upon to do anything because it was seen as the duty of male children to do that. You understand?
Yes, sir.
So, and then when my sister's husband dies, in the tradition where I come from, may God give him long life, my sister will inherit from her husband.
Yes, sir.
Yes, sir.
When somebody from my place, his wife dies, you do not inherit from your wife. Are you understanding now?
Yes, sir.
That when you look at jurisprudence, and there are arguments relating to certain concepts, you have to look at those concepts from context. What are the other things happening around this particular rule? I have aunties and all that who call to me that my child is this, my child. I have to look for money for them. Nobody calls my sister for anything. I have to use my own inheritance to look after my children. My sister's husband looks after my sister's children.
Yes, sir.
So some of these things are some of the thinking that we all have to do in terms of how we reason out and think about. Again, like I said, all these are my perspective. We must never lose sight of that everything I say here is just one person's perspective and other people will have other perspectives. Now, we said under that, we said that there is universal and local jurisprudence as enunciated by John Austin, that there are legal permutations that run universally, and also that there are those permutations that run locally. So we now come to a bigger question.
Yes, sir.
We ask ourselves things like, what is law, which we have already tried to define. We have talked about Okuniga's postulations about the lack of the death of what do you call it? The death of definitions. But there has been great debate in terms of what is the purpose of law. And people have debated what law is while focused on the purpose rather than the nature. Why? Because sometimes it is easier to define something by its purpose than by its nature. The other day, I had my undergraduate class, we had a conversation, and I said, in Nigeria, we appear to be unconcerned in Africa with what is happening in the outside world. We were talking now about secularists and faith followers being at loggerheads with each other, right?
Yes, sir.
Yes.
And then there are also people, now you have the LGBTQ, right?
Yes, sir.
Now, the LGBTQ will not be in existence without certain philosophies. And those certain philosophies come as a reason of very serious and exacting mental exercise. Because what the LGBTQ did was to say, look, people have the right to happiness. Free consenting adults should be able to live fully according to their relationship. And they should be equal to other members of the society. These were the same principles under which slavery ended.
Yes, sir.
The slavery of Black people in the United States ended under these same principles. So when you talk about certain things, there are certain principles that if you put those principles into effect, they give freedom to even classes that you had not thought of before. Which was why there was a redefinition of marriage in the case Hodges and Obergefell.
Yes, sir.
Where the US Supreme Court said marriage does not necessarily have to be between a man and a woman. Hodges and Obergefell said marriage can be between a man, or a woman and a woman. Now, we have gone through the same-sex marriage thing. What is now happening now is what you call sexual fluidity.
Yes.
Where someone can decide, I can decide and tell you today now that I'm a woman.
Yes, sir.
Yes, sir.
And if you call me a he, I can sue you.
Yes, sir.
Yes.
Bobrisky.
You have now, if you are clicking anything on the internet now, where a lot of times where you have to state your gender, there is male, female. The third one you see is non-binary.
Non-binary.
All these come out from philosophies. And in Africa, we are beginning to engage in those discussions without having the philosophy as the background to that discussion.
Discussions.
Which is what jurisprudence can assist us all in doing. So we said, Okunuga said, nobody, including the lawyer, has offered, nobody, including the lawyer, is offering, nobody, including the lawyer, will ever be able to offer a definition of law to end all definitions. But we also say it has not deterred lawyers from these scholars from this pursuit. Then we say here that as is usually the case about theories, most theories only capture a part of the truth, but never the whole. When you capture a part of the truth, and Duncanson and Samuels basically said something which I think was very important. They said truth is not a criterion we will use, which is the reason I was telling you that everything comes from a particular perspective. Truth is not a criterion we will use. Every reflection is by definition a true reflection. As long as the person that is uttering that reflection of what he's seeing is true to his view, then it is a true reflection.
Yes, sir.
Usefulness is the test of mirror gazing. In the device, we get information.
When we use it.
Which enables us to perform tasks that we will otherwise find impossible or more difficult. It is because of these reasons that people will tell you now that the positivist scholars were the ones that taught us most about legislation as a source of law. The natural law school scholars are the ones that taught us more about ethics and morality than any other school of law.
Yes, sir.
The realist school of law, and the sociological schools of law, for example, taught us more about empirical studies, about social studies, going into the society to study things. Why, for example, in Africa, don't we follow laws and regulations? Is this still because of that same ideology of reconciliation rather than retribution, where you just punish someone for doing something? Because if that is what is happening, then we must start reflecting that in our laws so that there can be some order in society as to what we believe and what we do not believe in. So for jurisprudence and our perspectives, is like a mirror. You can either take a mirror, look at it, put on makeup and do all that and know how fine you are before you leave the house, put on your tie, your shirt. You can use the same mirror, tie it to a rope, put it under a car to make sure that somebody has not strapped how many kilograms of bomb under his car to come and blow it up in your house. It is the same mirror doing different functions. I hope we are together. Then,
yes, sir.
One of the inquiries, one of the most important inquiries of jurisprudence, for example, has been the analysis of legal relationships. How do we relate to each other in a legal manner? What is my relationship as a solicitor, as a lawyer, to my client? What is a doctor's relationship to his patient? What is my relationship to my father?
Okay.
If I'm a 5-year-old child or a 6-year-old child, who is my guardian ad litem? What makes him my guardian ad litem? Am I mad? Am I insane? Is that why he's my guardian ad litem? Because an insane person too will also have a guardian ad litem to make decisions for him or her. So are you equating me with a mad person?
Yeah, exactly.
So some of these things are the things that we look at in terms of our analysis of legal relationships. Why? Because there are, for every giving, there's a taking. For every liberty or right you get, there are duties and liabilities. And for things that happen, you will find that there are differences in terms of how they happened, when they happened, and all that. So you use that to analyze relationships. If, for example, you call, because the whole world is tied up in relationships, what is Nigeria's relationship with the international realm? Are we tied to the UN Charter with other nations? Do we maintain our sovereignty by engaging in agreements or multilateral agreements with other nations? What is our thinking when we join, for example, the World Health Organization, who, by the way, at the Beijing conference, came out with a report that said to stop the HIV influx in sub-Saharan Africa and in other nations, particularly Africa, because Africa had 80% of HIV infected people at the time and still have it. And they said one of the ways to stop that was, in that report, one of the ways to stop that was people engaging in a monogamous relationship.
Yes.
And they said that and everybody was happy and they all came back to Africa. And the question was, if you have, for example, 90-something% of African countries and who believe in polygamy, either for religious reasons or cultural or traditional reasons, then how do we have a country that goes and signs on to that kind of report? And one of the countries that had the least number of polygamous marriages, and mostly Islamic country, Libya, was one of the 1 or 2 countries that actually raised any concerns. So how is a polygamous relationship, for example, different from the West or America, where what you have is serial monogamous relationships. Because on average, each one of them would have married up to 2 or 3 times.
Yes, sir.
Where you kind of divorce on demand.
Mm-hmm.
There are states that you just come in and you divorce. You don't need to give a reason for why you are divorcing. I just don't like the marriage, and then you sign off. And there are also other concepts such as a no-fault marriage. So you can marry a billionaire, for example, without a prenuptial agreement.
Okay.
A waiter, 2 years later, you decide to divorce the billionaire. Why? Because you, the waiter, the wife who cheated or the man who cheated, you are also the one asking for divorce, and nobody's penalizing you for destroying that marriage contract. Why? Because a no-fault divorce is what the law is. We are not going to ask for who was at fault. That does not matter in terms of who shares what aspect of the conjugal assets and properties. We just share it equally for you. It doesn't matter whether this one was behaving well, whether that one was not behaving well. It does not matter whether you are the one that cheated or the one that, you understand? And all those things,
yes, sir.
Yes, sir.
we fail to be able to trace to the activities of the secular movement. You're not going to go back to your church or your mosque and your imam or your pastor will tell you that it doesn't matter who was at fault in the marriage.
Mm-hmm.
It is secular people that will tell you that it doesn't matter. Why? Because there isn't any rules or regulations that are being followed. And because of that, they feel that they are morally neutral in the situation. So let's just go past this and say,
yes, sir.
Some of the things that you people, that both of you may have to think about will be something like, what is jurisprudence and legal theory? Give a thought to it again after this discussion. And I think somehow, while you're having that conversation with yourself or with other people, you will realize that your place in jurisprudence after this conversation has changed slightly.
Exactly, sir.
In terms of what you believe, in terms of what you think your duties are to Nigeria, to legal profession, and to the next generation, because we are talking about the heritage that you pass to other people. So when you finish the discussion, think again. Now, what do I think is jurisprudence and legal theory, and what is my place in it? Then 2, what is the importance of theory? Somebody called William Twining said, when you evolve theories, those theories have to travel well. What he means by theories traveling well is that the theories that are most important are the theories that you can use for in a broad manner. A theory you can use in the US, and then you can also come down to Nigeria and use it in an efficient manner. When you put 5 puppies from the same mother down to feed, there is one that they call the alpha male. That is the one that is the most aggressive and most dominant, and it may even be the most tiny one out of the puppies.
Exactly.
He's the one that drives everybody away until he finishes eating. Nobody can come near the bowl.
Yes.
That is what they call the alpha. And you look at dogs closely, you realize that there's a hierarchical structure. So if you evolve a rule for people living in a hierarchical structure, how does that work in the US? How does it work with us if you come down here? If, for example, we have a hierarchical structure of number 1, politicians at the apex.
Yes, sir.
Then the people in the next hierarchical structure are the rich people.
Yes, sir.
Then you have the next hierarchical structure being the people that are the intellectual elites. I'm assuming that is 3 down the line. The fourth one, the fourth rank in the hierarchical structure may be among the artisans and traders.
Okay.
And a 5th one may be among the poor indigent farmers in the village and in the rural areas? Can you evolve the same theories for these 5 strata of people? If you evolve a theory, for example, of say a lack of corruption, how we fight corruption and all that, do you think these 5 strata of people will obey it? Will the politicians obey it?
No, they will not.
Will the rich people obey it? The state can force the last 2 or 3 people in that hierarchy to obey it.
Oh, yes.
So when you evolve theories in terms of this is what you want to do, this is what you want to do, some of these things can furnish us with answers to problems that are ongoing in Nigeria as we speak. Because if you use first principles thinking to now ask yourself, okay, what is the nature of a politician? What is this? What is this? What is that? Which is what they do in the West. Then you now ask yourself, what is a billionaire? Whatever. Look for the nature, strip down everything, and then you try to reconstruct a strategy to deal with those layers of people. Now, that is one of the reasons, the importance of theories traveling well, that the theory should cover the field. Now, what does universal jurisprudence portend for the African continent, for example? We talk about corruption. If you talk about corruption and you just look at corruption as bribery being one of the key things in corruption, because when you look at the dictionary, like Abimbo said, you look at it, you look at one of the things they talk about is bribery. And they don't just talk about bribery, they talk about bribery to public officials.
Yes, sir.
If they are talking about bribery to public officials, for example, will an emir be a public official? Or an oba of a village or something? Are they public officials?
No.
Yes.
I don't think so.
It should be.
I don't know about it legally, but when you look at the larger society, obviously they are public officials, because there's a council of chiefs of every state, and then the council of chiefs is headed by the governor of a state. No, the governor, there's a council of chiefs, and then they make recommendations to the governor, who decides on what he wants to do. And there's a recognition in terms of the chief's edict of every state that says a particular chief is either a first grade chief or a second grade chief or a second. So yes, we can say that they are public officials, right?
Yeah. Yes.
Yeah. Can you go to the Oba of your village without carrying some yams to say, sir, I just came to greet you?
You must go with white envelope.
So will that be bribery of a public official?
That's paying an homage.
Paying homage. So you understand where I'm going now, and the kind of thinking that we have to do as scholars.
Yes, sir.
Because most other societies already have this thinking nailed down. You are not going to go to the Queen of England and carry everything that is given to the Queen of England in terms of gifts. They are doing coronation today. They pack everything and dump it to charitable organizations. That is what they do, both privately and officially. They have other ways of using their positions to enrich themselves, but it's more out of just image rights and little things relating to influence peddling and all that, that are not termed to be corruption or to be bribery. So we again have to look at some of these things. And then a question you ask, if you are doing your general reading, maybe with your phone or something, just ask yourself, is jurisprudence the same thing as legal theory? Are they the same thing as philosophy? Are they the same thing as empirical legal studies? I'm going to send this to your, I'll send you the video and then also send this to your, to the group, the slide. But, and then you also ask yourself, are they mere synonyms on their co-extensive pursuits of the study of law? Are they different completely based on purpose and all that? Is a jurist a philosopher? These are just general questions that I'm asking you so that when you sit down, the only way you can think it out is think it out in a jurisprudential, with a jurisprudential scholar's mind. By first of all using the 3 indexes that we discussed. 1 is the nature of the particular thing that you're looking at. 2 is how is it applied, the application. And 3 is the purpose. So when you look at all these questions we are asking, is a jurist a philosopher? Is an empiricist, for example, both a jurist and a philosopher, or he's neither? Those are the kind of things you just sit down and you think about. But if what you are doing is looking at the nature of anything, then it makes your thinking easier. If you are looking at its application, it makes your thinking easier. If you are looking at why, and the reason this is such an exacting way of doing things is because, especially for societies, not just for the legal system of society, but for societies, jurisprudential scholars must be at the forefront of the thinking for societies.
Yes, sir.
So when you see that even basic things like looking at marriage, for example, and you're married, I believe after these 2 hours, you will analyze it better than you did before. When you look at what makes me a man,
Exactly, sir.
what makes me a man, what makes me a father, which is a concept. Am I a father or am I a daddy? Those 2 things are supposedly mean 2 different things.
Yes, sir.
So we can take a look at all this, and then the way you analyze it now is different. You are not hazy in your mind. You understand that I have to look at the nature, I have to look at the application, I have to look at the purpose. There may be other indicators that you can create for yourself that you can look at in terms of analyzing some of these things. And you find out that some of the best judges are the judge. When we talked about Oputa, for example, here, and people like Carrie D. White, it is because they are reasoning in that manner that made some of their judgments, some of the best judgments you'll ever read anywhere.
Yes, sir.
When we talk about people like Lord Denning and all that, when they write from this same perspective, which makes their judgment, even a student, if someone comes, for example, and we are talking about the right to life, for example, the way Oputa would talk about it historically, before he touches even on the specific, he would have told you the nature of it, what it means, what it was deployed for, this and that, before he even goes to the judgment, and it becomes something to hand down to the next generation.
Yes, sir.
As a lesson, you know. So just think about things in that manner. And we say some of the ways of addressing these questions have been compounded into specific ways of thinking. And some of the ways of thinking is, we call them the schools of jurisprudence. Why? Because if you did your undergraduate at University of Ibadan, you find out that what we are doing in first semester now will be what we will do in second semester in the undergraduate program. Why? Because these are the things that talk about principles, which is a little more abstract. But when we talk about other things, you'll be able to understand why, for example, some of the things you are doing in your second semester will be some of those things that you did in the first semester in the undergraduate and whatever here. Why? Because now you have the basis for learning about jurisprudence and legal theory. So you can go straight into the nitty-gritty of it without ceremony. So some of the things we will be doing for the semester we've discussed will be the Positivist School of Analytical Jurisprudence, the Natural School of Law, which supposedly was the first school of law. And all the other schools are just a reaction, first and foremost, to the Natural School of Law, and then sometimes even to the Positivist School of Law. So you have the Historical School of Law, and a lot of the scholars of the Historical School of you have the Historical School of Law, then you have the Sociological School of Law. A lot of the scholars of the Sociological School of Law were originally members of the Historical School. Why? Because the Historical School talked about having a national consciousness as a basis for obedience to law and the understanding of laws. And then they followed that. Then they started propounding their own theory, realizing that there were mistakes that the Historical School had made, that they thought a different movement could rectify. And they started having what you call the Sociological School of Law, where now they were not talking about law as a historical impetus. They were talking about law as a social impetus, where they were now talking about social force as against nationalistic and nationalistic consciousness. So we will do that. Then we'll also do the Realist School, which is a school that will talk to you and talks about a realist scholar will basically tell you that the end product of what you get as law in the court is just a watered down version of what the law is. That the real law is supposed to be found, for example, in the police stations, for example. How do policemen arrive at what to charge you with? What kind of offenses do they arrest people for? What kind of offenses on the streets do they even overlook? How do they take their FIRs? What kind of advice and recommendation do they send to the DPP? Then they also talk about what happens in the DPP's office.
Yes, sir.
When this person is now charged to court, for example, and he looks for a lawyer, how does the lawyer advise him? What happens in the lawyer's office? A lot of these things happen, and then you can find out that the initial events that happen can turn into a completely different event when it gets to court.
Yes, sir.
Why? Because everybody is constant. We are using the process of what are the important elements of this. The man comes and he tells you a long story, and you reduce that story to, because there are elements under the penal code where if somebody steals, for example, they will say, okay, obtained without consent with the objective to permanently deprive. Those can be the elements of the crime, right?
Yes, sir.
And for the police, when he's investigating, that is at the back of his mind in terms of the information he's looking for. And there may be other information that will be as important as that he will overlook. And when you get into a lawyer's office, it's the same filtering process the lawyer is doing.
Yes, sir.
So when the matter eventually gets to court and the judge makes a decision, even the judge that's making a decision comes with a plethora of problems too. It could be a judge that has a liberal belief, a liberal attitude. It could be a judge who does not believe that sleeping with somebody's wife is a problem. So when you bring a diverse matter to him, the way he interprets the law will be in line with what is moralistic or his lack of morals state. Or for example, there is something relating to trespass or nuisance. Somebody dumps chemicals in a river and they bring him before you. If you are someone who is pro-business, the way you interpret the law will be different from someone who is pro-rights. Because a pro-business person is thinking in terms of, okay, if I tell these people to pay 1 billion naira, how would they be able to function? Will they be able to keep the workers that they have? What about the taxes they are paying to the states? What about this? And the realist school says all those things operate in the minds of judges. if I were a judge, for example, and an armed robber is brought as an accused person before me, after my robbery incident I just told you now, what do you think my attitude will be? You understand? So that is what the realist school were trying to say. Then you have obviously the feminist school that was also talking in terms of the rights of the female gender. And when you talk about the rights of the female gender, it talks about having a society that is patriarchal. What makes me, for example, the head of my home? It's a patriarchal society. That is why I'm the head of my home. Because I can tell you without any fear that my wife is 10 times more intelligent than I am. She solves problems easier than I do. But I'm the head of my home. And we are surviving on my stupidity. So, and the feminist movement initially started off as a wage equality. It was almost like a wage equality movement because men and women will be doing the same jobs. Men are getting paid much more than women are getting paid. Women were not even having access to those kinds of opportunities. So that was what it started off as. And it turned into, for example, in the West now, there is a call for them to have, the movement was so successful in the West, people are beginning to call for a movement for a men's movement. Because men are beginning to feel disenfranchised by the whole legal system that they felt was built and skewed in favor of women. And in Africa, we haven't got into that. And then there's another movement that is a danger to even the feminist movement as we speak, which is the LGBTQ movement, especially in terms of principles relating to gender fluidity. In this last Olympics, you saw a transsexual, a man that turned into a woman in the weightlifting competition, competing against women. And it's happening at almost every level in the West now and in the US. So what is beginning to happen is that you are beginning to see a destruction of female sports. Because you are not getting, there are also transsexual women, transsexual men, women who become men.
Yeah.
A particular actress called Paige just became a man some months ago. But she's not going to go and compete in men's weightlifting. So the transsexual movement is not a danger to the opportunities men will have, for example, in sports, in entertainment, for example, but it's a danger to the feminist movement. Or because they came upon almost the same principles as other movements, such as the feminist movement, feminist scholars are afraid to open their mouth to say this is wrong. Because when you have a certain philosophy, then it becomes much more difficult to go against that philosophy. Now we'll do that. We'll take a look at the critical legal studies movement. And the critical legal studies movement is more talking about things such as hierarchy in societies. That law is basically generated based on the interest of certain classes in society. When you make a law, when you have a law, an easy example I normally use is the law against theft. That you steal what does not belong to you. If the burglar that enters your house to come and steal, whose house do you think he's looking for? Whose house? He's looking for somebody that has property, right? So that he can steal it.
Yes, sir.
So when you think back at a lot of laws that you thought were there for the protection of everybody in society, you will realize that many of these laws according to the critical legal studies movement, are there to protect certain classes of society, not everybody. If I don't have a property, I will not be afraid of a thief.
Yeah, exactly, sir.
So the thief is stealing from the people who have property, and the people who have the most property are the rich people.
Yes, sir.
Because in the same token, the politician is stealing from the state, and the state ignores it. But the burglar enters someone's house and steals a car or something, and then suddenly the state jumps up in umbrage and says, "How dare you steal? Don't you know there's a law against theft?" So we'll go through, we'll have that discussion. Then there's the African philosophy of law. Somebody called Idowu wrote fantastically about that. We'll also do that, where does it even exist? Is a question that people ask, you know. And then there's the race theory. We may not talk about race theory, law, and economics, but at your own time, it may be interesting for you to take a look at and read. So for this introductory class, the next class we'll be doing, I think it will be anchored by Emmanuel, because I think the next class we are going to do will be sources of law.
Okay, sir.
So we can decide to meet. I'm hoping that we can meet physically for that discussion. But what I really want us to do is have a hybrid, because this is COVID times, and we must behave like there's a problem, even though the larger society do not behave that like there's a problem. But there is a problem. I talked to a doctor about 2 days ago. He's an eye doctor, and he was very surprised when I told him how many members of my family COVID-19 has killed. He was shocked. And I told him a lawyer cousin of mine who lives in Lagos died 2 weeks ago, as a matter of fact, from COVID.
Oh my God, I'm so sorry, sir.
You know, the Chief Justice of my state died from the same thing. He's from my place. He's like an uncle to me. So because of that, I'm a little more sensitive about issues relating to safety in a pandemic than maybe the average Nigerian. But we'll find a way to also have physical classes for some of our classes. So for that, that will be our next lecture. So you prepare in terms of how you anchor us for that. The reason I'm saying you should anchor some of these processes is also so that the way we think is different. We think independently, we think from different perspectives. And I can guarantee to you that after this semester, the way you look at law will be different.
Okay, sir.
Because the way you look at, not just law, the way you look at every other thing in terms of thinking, and then you gain confidence by being able to structure a class and say, okay, this is the kind of discussion that I want. I'm not interested in what you are saying now. This is what I'm interested, because we are all trying to get better. So hopefully we should be able to do that. But during the process, we can still be using our WhatsApp to have discussions and all that. Any comments so that we can round up?
All right.
Then just so that I add it here, what I normally do, because what in jurisprudence, it's the cause of the cause.
Okay.
Why I say is the cause, what I'm about to tell you is the cause of the cause. That's that the cause is C-U-R-S-E.
Okay.
The cause of the cause. The cause is jurisprudence and legal theory, right?
Yes, sir.
The cause of the cause is volume. Too much, it requires too much information. So a lot of people sometimes get discouraged by the amount of information. Don't worry about that. What we are having is a discussion. When we come for your examination purposes and all that, we just sit down, do a review. We tell you what you are going to be examined upon.
Okay, sir.
And then you can just cut that down to, okay, I don't have to focus on this. I don't have to focus on this or this. This is what I need to focus. And you do that for the purpose. But more importantly is the discussion we are having.
All right,
Okay, sir.
So any other comments?
Yeah.
Okay, then I'll be
Please,
calling off.
Have a comment too, sir. Thank you for your time.
No, it's my pleasure, please. It's always a joy to see people who say they want to learn jurisprudence.
yes, sir.
I'll be calling off. Then hopefully we can, if there are any discussions, any questions you may have, anything, just use the WhatsApp, whatever. I'll react to it almost immediately.
Oh, all right,
You
sir.
will, sir.
All right, sir.
So have a nice day.
You too, sir.
Thank you very much, sir. You too, sir.
Yes, sir.
All right, sir.